We'd like to go back to one of the questions we had because we have now figured out exactly what was meant by the terminology. The question was, for what do you use the alpha index for 2017 ICD-10 CM?
And I kind of think that it might not be as much of a question as a for what you do, you might want to use the alpha index for 2017. That might have been what the questioner was saying, was offering that as a tool. And so we Googled that and looked that up real quick, and it is an alphabetical listing of the diagnosis codes by description of what the injury is, which might also be a wonderful tool for you to utilize. I'll certainly take a closer look at it. Not sure exactly how searchable it is, but if you can actually search the full code with the period in it using that and it works for you, then that would be wonderful. So if that is just a hint for us, then thank you to whomever wrote that in. Appreciate it. Okay.
Thank you. And by the way, we believe that the codes will be the same, whether you're doing the alpha index or using the portal.
Right. It's just they're just listed in a different way. So the thoughts on it were that if you know what the injury is and you can search immediately to the injury, that might be the code. But if you only have the code and you don't know what the injury is, we're hoping that tool is also something you could search by the code number and then you could get to it. So we'll definitely give that a look. All right, so we're going to switch gears a little bit now, and we are going to talk about resolving a Medicare claim through the compromise or waiver process. All right, so I have a little slide here for you, and basically I think pretty much everybody knows Medicare is entitled to get repaid, but the authority for Medicare to do that is given under the Federal Claims Collection Act at 31 U.S.C. 311 et al. At sequence, and at the CFR at 42401.613. It also has the ability, as it says real clearly, to waive its recovery, and that's under the Social Security Act. So the Medicare contractor, the portal, the MSPRC, the BRC, BCRC, they're changing the names, so I know that it's not called MSPRC any longer, which rolled so easily off your tongue, so now it's the BCRC, the Benefit Coordination Recovery Contractor Center. It's harder to say. They do not have any authority to compromise Medicare's lien. The Centers for Medicare and Medicaid Services has that authority. They're just an agent. The BCRC is just an agent. The portal is just the agent's tool to process the claims and give everybody the information. If you are actually interested in a compromise or a waiver, you will actually be dealing with the Center for Medicare Services directly. Compromise requests, you can make a compromise request pre-settlement or post-settlement, either or. The example that we're going to go through is going to be a pre-settlement compromise request that we did, pre-settlement. We didn't do a post-settlement. We knew we had a situation and we wanted to see if we could get the Medicare program to work with us. So they do actually have an ability and a process for basically negotiating the lien. You can't call them up on the phone and just say, hey, let's work out a deal. It doesn't work that way. You still have to submit your request through the BCRC, through the MSP, whatever you want to call it. You have to submit it through them, and they transfer it. You're going to make
everybody crazy with these acronyms.
Okay, I'm going to stop. Okay, so I'm going to stop. All right, so there are multiple factors that that CMS can't help it. That's what they're called.
I know.
Everybody knows that Medicare uses. If your client has an inability to pay and the cost of collection does not justify the enforced collection of the full amount of the claim, they can enter into a compromise. If there's an inability to pay within a reasonable time on the person, on the part of the individual against whom the claim is made, or if the chances of successful litigation are questionable, making it advisable to seek a compromise settlement. This is the situation that the law firms will deal with more frequently than not. You want to help your client. You want to get them something for the fact that they were injured, but you know the Medicare claim is going to far outweigh outnumber either the policy amount or
the recovery.
Yeah, the recovery. So, you have to think about the numbers. You'll have to look at it and say, is it, even if we get a compromise from Medicare, is it worth it? If you've got a client who has hundreds of thousands of dollars worth of medical care and it's a $25,000 liability policy, what are you doing? That money is just going to go back to the program. There's not really any point. Your client's going to get their medical care all paid for by the program. Don't fight it. It's generally it's not worth your client's time in a situation like that. But there are lots of times where it might potentially be worth it. So compromises you can request before or after you settle your case. Waivers can only be requested after the case has settled. Asking for a waiver is basically a very detailed process, and you've really got to, basically have to be no ability to repay the Medicare program in order for a waiver to be granted. But we're going to review both of these. So I'm going to take you in here, and you might recall from the earlier presentation where we showed you the $138,000 lien that got reduced down to a $994 payment. Initially, when we had this case, before I got involved in it and they didn't realize that they could still dispute off those hospital charges, the attorney had initially come to me and said, hey, can you help me? I want to do a pre-settlement compromise because the Medicare lien is too big, and it turns out that our claim is not as big as we hoped it was going to be. It's really only going to be about an ankle fracture. And so we're talking about settling the case, but we really need to do something because the lien is huge. I think at that point the lien was the $66,000. We'd gotten it down to that level. But the settlement offer was $72,000, so Medicare was going to eat up all of it, and the client wasn't going to get anything. So our client at that point, our client had passed away, and we were representing the estate. And the estate said, we're not going to go to trial and do all of this and keep fighting this if we're not going to get anything out of it, and all we're going to do is pay attorney's fees and repay the Medicare program. So he asked me if I would submit a compromise request to Medicare. So we did that. So the way that you submit a request and make it as clear and as obvious to the benefit recovery contractor as you can that this is a request for a compromise. So you can see at the top of this slide where I've wrote request for pre-settlement compromise in bold. I've underlined it, and I've also told them where to send it to. Figure out wherever you happen to be, which regional office you covers your area. That's really easy to find on the CMS.gov website. Find out who handles claims for your area. In Maryland, our claims actually go to the Philadelphia regional office, so I'm even pointing it out to them. I'll say that because even though that was there and it was clear that it was there, they didn't send it over. It probably was about 4 months before this actually got where it needed to go to get reviewed by the appropriate people, and that required some phone calls actually to the regional office for them to actually reach out to the recovery contractor and request that they send it over. So, but the process really isn't that complicated. So you do just put together, and basically what you're going to be doing in a situation like this is you need to look at a pre-settlement compromise basically the same way you would put together an entire demand package to your insurance company to try to settle your case. You're going to provide them with absolutely as much documentation as you can. So in this case, what we asked the Medicare program to do, we told them all of the information about this case. We told them that there was a $72,500 offer to settle the case, but that the lien was at that point $66,000 from the CPL conditional payment letter that we had. And that we were representing the estate on a 40% contingency, that we had expended about $6,000 in costs already at that point to get the settlement offer on the table. And when we worked through the repayment amounts and determined what the estate was going to have to pay back, it was going to only result in about a $3,000 recovery to the estate. I think there were 3 or 4 children,
Right.
and this just was not acceptable to them. They were just not going to go. They were not going to go through with this if that was all it was going to recover. I'm sorry. So what we did, and we're very fair. We said, why not a three-way split? So we asked them straight up, and we said, how about an equal division with, you get a third, we get a third, and the client gets a third. Nobody's happy, but nobody's entirely unhappy either. So we thought that was a fair compromise. And so we put that out there and asked them if they would be willing to do that. And we reiterated to them that the reason why we wanted to do this was that we thought that our chances of being successful in litigating this case for more money than the settlement offer were very slim. So then we provided them with all kinds of documentation for them to make their decision. You can just write them the letter and ask for the compromise, but if you don't give them something to hang their hat on, they're going to come back to you and say, give us something. So you might as well give it to them right from the get-go. So I would present a pre-settlement compromise similar to presenting a demand package to your insurance company. You provide them all your medical bills, your specials, your lost wages. You're going to supply the Medicare program with everything you think it needs to give you the answer that you want. So we provided them with we sent them our actual demand letter that we had initially started this case off with, and there's a sample of our demand letter that we actually sent them. Sorry for all the blackouts, but this is a confidential settlement, so we're keeping that information to ourselves. And then we sent them also a copy of the letter that we got back from the actual adverse insurance company, where they were pointing out all the weaknesses in our case for us, which we knew what they were. But they were pointing them out, and they put it in a nice little letter, which frequently we don't get, but in this case we had it, so why not give it to Medicare? The whole purpose here was to get this lien compromised.
Under the theory that a little of something is better than a whole lot of nothing.
Correct.
And that's why things that were oppositional to our case, which was the letter from...
Which you would never give at any other time,
exactly,
but in this
right.
situation, you're dealing with Medicare. The case, the settlement was there. It wasn't going to get any better. We were either going to file suit, which the estate was not willing to do, and the firm didn't have any desire to do either. We were just going to walk away from it. So we really needed the settlement, but we needed Medicare to work with us. So I was trying to give them absolutely everything that I can. So what we also gave them was a copy of a letter. We spelled out to our clients exactly what the issues case were and what we were trying to do, and that we were limiting this case. It was only going to be limited. So again, we're establishing to the Medicare program that the chances of successful litigation of this claim are so small that we really need this compromise. We gave them that letter. I think we gave them... Yeah, the same stuff.
Mm-hmm. Right.
Yeah, and a copy. There was a part up here I missed somewhere. We gave them our expert's opinion, which was saying, that we're going to have a hard time proving it. And again, I'm going to point out, nothing that you're sending to Medicare has to be that fancy. This is really how we got the opinion. I mean, we just talked to him, and he just shot us over a little email, so I just printed it out, and that's what we were doing. The case was what it was. We're trying to do our best for the client at that point and not just walk away from it. Okay, we provided them a copy of the proof that the settlement offer was there. We had a copy of the release that hadn't been signed yet, but that there was a valid $72,500 offer on the table. All right, so you provide all of this information you submit it to the BCRC, which everyone who's dealing with Medicare is familiar with. That is where all the paperwork comes from. It's that address that's at the bottom of every letter that you get. But they then send it over to the regional office. So we had submitted that letter. I'm sorry, I'm not going to go all the way back. We submitted it in March of 2015. And in June, finally, after multiple phone calls and getting the CMS to call over to BCRC and say what's going on, they forwarded it over and they sent us a little response so that this would be the letter you would normally get back from them right away when they do it correctly, to say, we've got it, we can't do that, but we've passed it along to the Philadelphia regional office. You could send it directly to the regional office. That is not the way they require you to do it. So you could send it, but it probably is just going to get ignored. So the best thing to do is put it through the process, they need the recovery contactor to know what's going on with the claim, so they stop doing all of the things and don't make an effort. If they're not kept in the loop, they could potentially settle the case where there's something out there. You could have people make mistakes, and so the BCRC needs to put the claim in this process on the portal that stops everything that's going on their end while this process gets reviewed by the regional office. So that's why it has to get submitted to them. All right. So that was the letter we got back from CMS. Oh, did I skip something?
I don't think so.
Okay. So they finally did forward it over, and in July, they're actually pretty good about getting back to us. The CMS is actually pretty good about reviewing these things, getting back to us. They wrote back to us and they said, we reject your proposal. I was devastated because I was for certain that they were absolutely going to agree with us. And as we look at this letter a little bit more closely, you'll see why exactly they rejected our proposal, which truly they actually accepted our proposal. Okay? So what they did was they reviewed the amounts and they said, we will compromise your claim, but we won't accept the $21,000 that you asked for. We'll accept $30,000. When we did those numbers, that still wasn't really going to benefit our client any. But what happens with your Medicare claims, they never stop growing until you tell the system that the case is settled. So while we had a settlement pending, the case wasn't over. So what was happening here is, if you see on the second page, they did their compromise calculations not based on a $66,000 lien. The claims had continued growing, and now the claim was showing that it had $84,000. So they were willing to accept $30,000 on an $84,000 claim, which is actually a win. The reality of it is that those claims that they were making it on were not related to the injury and needed to be disputed off again. So thankfully, when this came back and they said that, hey, we're not willing to take what you want, but we're willing to work something else out, we took another look at it. That prompted me to actually go back and look at the backup documentation to say, wait a minute, why are they using 84 when I thought the lien was 66? I hadn't reviewed the information. I had just been given some details by the person that was handling it, and they said the lien was 66, so we were doing this letter. And that's when we discovered that it still had all of those hospitalizations in it. So instead of actually accepting Medicare's offer here to settle the case and pay them $30,000, we actually went back and redisputed the unrelated claims off of the conditional payment listing and got that lien down to $1,800 and paid back the program the $994, and the estate, the clients were thrilled. So this is the process, and this is just some backup paperwork for you to refer back to, if necessary, for the process for doing a pre-settlement compromise. I think all of this is my notes on pre-settlement compromise, but I pretty much said everything I think that I had.
Ready to move on to
yeah.
waivers? Okay.
No, yeah, I think we're going to, that's what I'm waiting for. I just wasn't flipping the pages because I was pretty familiar with this information. So again, this also is somewhere where I want to say that this really highlights the importance for you to educate yourselves and your staff on how to analyze and do a dispute of Medicare's claims. When we started this particular case, we didn't know what all our claims were going to be. We knew that our client had been injured, and when the family came to us, they thought our client's, all of her illness and everything that was going on was because of the treatment and the injury itself. Mm-hmm. And so when we started this case, we threw our net wide, and we alleged everything and anything that had happened and anything that was going on, including the death of our client, was as a result of negligence of third party. So we had, when we initially reported the case to Medicare, we had reported bed sores, we had reported deconditioning, and we had alleged that she had died because of the negligence of the third party. So you can understand how that lien ended up being a $200,000 lien at the time that we received it, because everything we were alleging that everything that was wrong with her was because of the negligence of a third party. So Medicare wasn't wrong in putting all of those claims on there initially. The problem is, when do you report those cases? When do you report those claims to Medicare? And how much do you tell Medicare that you're actually looking for when you haven't really fleshed out your case? There's some people who say, you instantly report your case to Medicare the minute you get your client. Tell Medicare, get them going. I agree if you know what your client's injuries are. But in your unique cases, your medical malpractice cases where you're fishing and you don't really know what you're going to be able to prove, you might want to consider waiting a little bit until you've really got those things narrowed down to what you really think you're going to actually be able to prove before you put notice of Medicare, hey, these are my client's injuries, because it will make your process much less complicated if you're only dealing with claims that are injury related instead of dealing with any and everything that your clients have ever done. So it's very important to analyze, your case and analyze your lien when you get it. So, but that was why that started out so big. All right. So the next slides that I have for you, so that's the pre-settlement compromise, and then the other option that you have for how to compromise a claim for your client is to request a waiver. I don't have a lot to talk about with regards to waivers. It's not something that we've ever had to do for one of our clients. I've had
not since they created the portal. We've had issues before then, but not since they created the portal.
Okay. I'm not certain that we've done waivers with Medicaid liens and whatnot, but the process for requesting a waiver of Medicare lien, you're basically working under the Social Security Administration Act, and so the form, it's about 9 pages, I think, and so I put it in the material so that you can take a look at it. It's called an SSA 632 BK, and they ask for every bit of financial information about your client. I mean, if your client has any money at all, they're not going to qualify for a waiver.
Right.
I mean, they basically have to have nothing. I would say that
I think the waiver is the Hail Mary pass
right.
of trying to negotiate your Medicare lien.
Yeah.
I'm sorry, go ahead.
That's okay. I have a note here. It says we had an extremely wealthy client who had a claim, and they had a lot of businesses. They had so much going on, but they wanted every penny of our legal expertise put to test for them. And so they were like, oh, hey, there's a waiver process. Why don't we ask for one? Regardless of the fact that we told them you're never going to qualify, and they knew they weren't going to qualify. Just in principle, they said, well, you never know until you ask. And I understand that thought process. But luckily, I was able, all of the information that this form asks for is very private, personal information about your finances. I didn't have this information in my client's file, so I had to send her this form and say, okay, here's the process. She took one look at it and sent it back and said, no thanks. So it saved the day, actually. So if your clients don't have anything, and it is somewhere, and it could even be potentially one of those limited liability policies that it might be to your client's benefit, certainly, if their situation is very, if they don't have anything, this form wouldn't be that difficult to fill out. It just hasn't occurred.
You have to remember that the waiver is the afterthought, because you've missed the pre-settlement compromise. You've missed the negotiations during the time that you were settling the claim. And now when everything is said and done, there's nothing left to do except to ask for the waiver. And Medicare is extraordinarily reluctant to give you a complete waiver.
Right.
They would much prefer to try to work out a compromise, but
you'll get a quicker response if you just try to get a compromise.
Yeah. Yes.
All right. So that's the end of that section. I don't know whether we should. I don't think we need a break at that point. All right. So you can see how long this form is. All right. So I wanted to go back and just go a little bit further in detail over consent to release, and I think Steve might have some feelings or opinions on this that he might want to share with you. So in our practice, we have an occasion where insurance companies try to twist our arm and tell us that we have to give them access to our client's Medicare information. We have to give them the conditional payment letter. Or they'll tell our client right from the beginning, before the client's hired us, they've received they've contacted the insurance company. The insurance company is immediately, and I'm sorry, I'm throwing Geico under the bus here because they have to be the first letter I came across in one of my files that was kind of showing this information here. And what they're asking for is a consent to release from your client for them to have access to your client's Medicare portal, for them to be able to upload this information and for them to be able to see the claims that are associated with your the conditional payments that have been made on Medicare's behalf related to your client's accident claim. This would be totally fine with me if Medicare got it right every time. But Medicare doesn't get it right every time. They make a lot of mistakes. They put a lot of unrelated claims onto that conditional payment listing initially. It's our responsibility, and we are the advocate for our client, where we are looking that over and making sure that the claims that are included are only related. In the pre-litigation stage of your case, if you provide your insurance company with open access to your client's Medicare, you could potentially be giving them all the information and all the negative information that they need to use against your client as to why they're not going to settle the claim. All of those other charges are going to lead them to other medical care that your client has. Might not have anything to do with the accident, but might be something that the insurance company wants to use to say why your client really isn't entitled to the settlement you think they are. So I will never have my client sign one of these, but if you'll see on this particular letter, right at before it starts listing the 1, 2, 3 items that they need, the last sentence says, "We require the following information from your client in order to meet the statutory requirements of Medicare program. The insurance companies are responsible for reporting all liability settlements to the Medicare program." So they have every right to ask you for your client's name, their Social Security number, their Medicare number, if they're a Medicare beneficiary. But on this letter, you'll see at number 7, it says completion and return of the attached consent to release and status inquiry form provided to us by Medicare. Medicare makes this form here available to the insurance companies to use so they can do their reporting requirements. Medicare does not require that your beneficiary, your client, give this form to that insurance company. They just require that the insurance company report the settlement. They can do that without being able to look at your client's claims. So you can give them your Social Security number. Uh-oh.
Our lights went out again.
You can give them the Social Security number, and you can give them the name and the date of the injury and all of that information, and the insurance company can properly do their reporting, but don't give them the consent to release form. It is opening up Pandora's box to the insurance company for any and everything that your client has listed on those claims before you've ever even had a chance to look at it and dispute it.
We look at it in our office the same way when an insurance company wants our client to sign a medical authorization for them. Under the Maryland rules and the D.C. Superior Court rules of civil procedure, there's no requirement that our clients do that. I don't want the insurance companies having access to our clients' medical information, particularly before we, as their advocate, have that same information. And we do the same thing with Medicare. It doesn't make a difference. We know they have a reporting requirement, and we know they're on the food chain, so we give them the information they need for that, but not access to the actual portal.
Correct. Not access.
And we'll copy them, if necessary, on correspondence that we send to and from Medicare, especially when we get to the stage for the final payment. But
right.
but they're not going to get the access to our clients' information.
I have no problem also with giving them the conditional payment listing once it's been disputed and it only contains the claims that are related to the injury. I just don't want to be giving, especially in pre-lit, the insurance company any additional information that they can use to go searching for things to use against our client down the road.
Because they'll use anything, and this is just more ammunition for them.
Okay, and so that's something that we frequently see. So what I did, this is the information that is on Medicare's portal about the consent to release form. There is consent to release model language available through the portal on both consent to release and beneficiary proof of representation. You're not required to use their forms. This form is never necessary for an attorney to have their client complete this consent to release. You represent them. Your proof of representation is what Medicare wants to have on file. It's a higher authority level. It gives you access to look at those claims. But it does also, if you do give this to the insurance company, it does give them an ability to look at and view the claims that are on the portal, so you definitely don't want to give them this. Use your retainer agreement. It's simpler, it's easier, or use a proof of representation form if you want, but do not use the consent to release for the clients that you represent. All right. So I wrote on here, the lawyer controls what the insurance company gets. If you want to give them the CPL, go for it. Hopefully after you've analyzed it and disputed off all the unrelated. And also when you give them that CPL, block out all of the conditional payments. The insurance companies are wonderful for saying, in some states I understand that the laws are different. Here in Maryland, they don't get a benefit for the fact that the client only has to repay the amount that the Medicare program actually paid. They're able to make their claim based on the full amount of their medical bill. You don't want the insurance company to know that
Well, with one exception, in medical malpractice cases in Maryland, they get that credit. So
they do get that credit. So in a medical malpractice case, it's not going to make a difference. But when you're still negotiating it, that only applies, and that gets reduced after you get a judgment, correct? Right. So during the entire course of negotiations, I would say don't give them that information. If you're going to give them the CPL, make sure you cover up what the conditional payment amount was, and just give them the amount that the bill actually was. All right. So if you get a request from an insurance company to have your client, I provided you with a pretty simple little letter sample that says, I've received your correspondence and your email regarding obtaining a consent to release, authorization from my client to allow Geico, to communicate directly with Medicare concerning the conditional payment obligation. All right. So I just tell them we have already placed Medicare on notice of our client's claim. We're fully aware of the requirements to reimburse them from any recovery, and once we receive the letters, and taken out any unrelated claims, we'll be happy to give it to you. But we're not giving you any sort of consent to release, authorizing any direct communication between the insurance company and the Medicare program. So, and we're being very nice. My apologies, but I trust you'll understand. So we haven't had any problem with it.
Never.
I do understand.
No.
Yeah, we have. All right. So that's what I just wanted to revisit that, because that consent to release is a very sticky situation. And insurance companies really are putting a lot of pressure on the attorneys and saying, well, I'm not going to give you, I'm not going to settle the case with you until you give me this letter from Medicare. They don't really have an obligation to require you to provide them with anything other than the information they need to properly report the settlement to the to the Medicare program. Okay, that's that.
Okay, you want to do repayment options?
All right. So now we're going to move into our section on repayment options. And what I wanted to do and be able to help you guys with here, it was like, how do you actually figure out how much Medicare is really going to have to be repaid? You've got a conditional payment letter, there's attorney's fees, everything's kind of fluid, but you've got your CPL, that it only includes things that are actually related to your accident, nothing on it's going to change, but you've got a low offer on your case. You might want, it might be a good offer, you might want to be in a position to counsel your client about it. How can you really predict what you're going to have to repay the Medicare program? So that's what I wanted to show you here. All right. So the formula for how Medicare gets repaid is found at, I forget how to say this, 42 USC 411.37. So it's a federal regulation. This is where you can find it. This is what a copy of it is. And it spells out exactly how the Medicare program gets repaid. But all of us aren't math geeks. I know I'm not. Steve is, but I'm not. So what I did was took this actual language that's in this and I created a formula that you can use when you're negotiating your settlement, and you can change it, and it's an Excel spreadsheet, and you can just quickly change your settlement amount, and it'll pop in immediately what your actual repayment amount is going to be. But that's assuming that your settlement is greater than the Medicare lien. All right, so if you'll take a look at this, it says, let me find my actual slide in here as well. I made some notes on these that are somewhat helpful. All right, so it says that if the Medicare payments are less than the judgment or settlement, the Medicare then Medicare will apply the pro rata reduction. So you determine the ratio of the procurement cost to the total judgment or the settlement, apply that ratio to the Medicare payment, and the product is the Medicare share of the procurement costs. All right, so you then subtract that amount from the Medicare payments, and the remainder is the amount that's owed to Medicare. That's a word problem to me. It takes me right back to high school, and I'm like, okay, I'm not a math geek. I sat down with that and said, I really need this to work for us easier, so that's where I came up with the little formula, had it reviewed. So we've used it. It works to the penny. It can be off by a penny. Depends on where you put the decimal point or where Medicare puts the decimal point, but I do have the worksheet here for you. But this only works if the Medicare lien is less than the settlement. If the Medicare lien is greater than the settlement, say you have $100,000 in specials, but you only have a minimal policy, a $30,000 policy, all you can do in that situation is deduct the procurement costs, which is the attorney's fees and whatever the advance costs were, or the procurement costs were. The rest of the money, all of the money, goes back to the Medicare program. There's nothing, no other reduction, no other formula that needs to be applied to it.
Unless you work out a pre-settlement
yes,
compromise.
but if you haven't worked out a process, and this is why in those situations where you do have someone who's really hurt, are dealing with a minimum policy, it just might not be in your client's best interest. We aren't going to take a case of that nature assuming that we're going to get a compromise. The program's not required to give you one. So there are times when we are dealing with really bad injuries, very limited policies. It's really, really sad on those days where you have to tell your client, we're not going to do it. But I can only imagine it would be much worse if you took their case and you were allowed to take your fees and then gave them nothing at the end of the day. So we just generally won't do that. But the formula does apply as long as the Medicare lien amount comes in less than the settlement. So I'll give you, I don't have these in exactly the order I want it to be, but this is the settlement worksheet formula. And the calculations that are being done are explained there. Like, for example, it says ratio of procurement cost to settlement in line 6, and that is line 5 divided by line 1. So you can set this worksheet up for yourself or for your staff, but I'm actually really pretty generous with this formula. So if you send us an email, I don't know if we give our emails out on this, but if you send an email through Alex or through the CLE, I will happily shoot you a copy of this worksheet. It's great. It has really made our settlement of our cases a lot smoother because all you have to do, once your costs, you know what your costs are, you can be sitting in a mediation trying to settle your client's claim. You're going to pay Medicare back based on what your case settles for, not based on what the lien amount is. It's going to, because it's pro rata. So if you settle your case for $100,000, you're going to be paying Medicare back a substantially different amount than if you settle your case for $200,000. So you can instantly sit there, and the attorney can have this little worksheet right on their phone, right on their app, and they can throw the numbers in there, and they can instantly see how the Medicare lien changes based on what the settlement offer is. And as an added benefit, I added, what's the client's net going to be? This formula itself is just what the amount is. So it's going to add in and tell you exactly what the client's going to net based on what the offers are. So that's something that's really, really helpful as part of the repayment process. So I'm going to go back a couple screens here. There are a couple of other options that Medicare now has for repaying. The first one here is called the fixed percentage option. This is only for claims that are under $5,000. That's not a substantial amount of our practice. I'm hopeful it's not a substantial amount of your practice either. Those are your really, really tiny little cases. And so honestly, I haven't had an opportunity to use the fixed percentage option, but this is the information. It's really pretty simple. I think that these are designed more for beneficiaries who are settling their claim with Medicare. They're settling their claim with the insurance company directly and are also settling their claim with Medicare directly. These aren't really intended for attorneys that are handling clients' claims. I mean, if you're
we're sort of the third wheel if we're getting involved at that part.
At that point, exactly. So, however, if you'll look at this fixed percentage option, am I in the right one here?
Mm-hmm. Look at the top.
Yeah, here it is. I'm sorry. So the fixed percentage option actually has your client repaying 25% of whatever amount that they receive. So it doesn't, if it's $1,000, they're paying $250. Well, whatever it is, they're going to be paying that amount. I would suggest to you that your Medicare lien's probably not $250. It's probably not even 25% of what your client is receiving. So if you are looking at this and you're thinking, hey, this is a quicker way, I'll just go through this whole process, I'll just pay them this amount. If you get your case isn't settling the day it walks in. You've been working it up. It's been sitting in your office for a little while anyway. You could have written to the Medicare program, got the information back, and get an actual conditional payment letter. It might have 2 claims on there, So the chances that your client's going to actually settle their case for $5,000 and that 25% of that should be paid back to Medicare is probably pretty slim.
Yeah.
So it's here, it's available. I wanted to provide it, talk quickly about it, but I wouldn't recommend it. All right, and the next option is this new self-calculated conditional payment amount. And again, this is model language. You're not required to utilize this. This is provided through the CMS.gov, through the portal. These documents are there. You can find them. The self-calculated amount only applies to claims that are $25,000 or less. So again, I found little benefit to these new procedures. There's things that the program is rolling out because it has in the past been so tedious to get your Medicare claim resolved. So they wanted to come up with these things to really move the little cases along. These are not intended to be the way you should be resolving your big Medicare related third-party liability claims. These are for these little tiny claims that were bogging down the system. So the program came up with these new procedures to be able to do that. But again, if you read through this one will tell you that you have to wait 6 months before you can do this process. You need a certificate from your doctor that you're not having any more treatment, or else your client has to certify that they're not having any treatment and that they haven't had any treatment in over 3 months before they're even able to initiate this process. If you've already got to wait 3 months before you can even do this, just do the regular process. Report the claim. You'll have your information. And again, you're not on the hook for trying to determine that it's the right information. All right, so you have to go through, in order to take this opportunity, take advantage of this conditional self-calculated option, you still have to do all the legwork. You have to do all the legwork because you have to pull all the EOBs. You have to calculate the amount. You have to pull. This is assuming you haven't reported anything, and that you don't have a CPL that Medicare's already provided to you. So you've got to pull all the documentation. You've got to get certification. You've got to make sure that you're adhering to all of these time frames that are required of this. You've got to add up all the claims, calculate the procurement amount. I can't see that this is a benefit to anybody.
I don't think so. Looking at it, yeah.
It's just going through it. So we haven't utilized it.
Just reading your notes, yeah.
Right.
I
so
agree
it's
with
just
you.
simply a matter of it. If there's someone here that wants to advise a client that there is a process that they could do it on their own, that would be fine. But then this is only a request. that you're submitting to Medicare. This isn't a, hey, here it is. This is a, hey, this is what I think I owe you. Can you tell me if I'm right? So they're still going to get it, and they're still going to review it, and they're still there. You're turning it over to Medicare to say, nothing's been disputed. You haven't looked at anything. I would say I wouldn't recommend it. There's no time savings in doing this. It would probably be to your client's advantage, best for you to advocate for them to just go through the process, make sure you're disputing off the claims. I don't see any time savings, but it is there, so I did want to talk about it. Okay. All right, so that essentially brings us to the end of the information that I have available for you guys today. I do have a few more slides that I included here. Let me see if I can get down. That's the worksheet. Email me, email Steve. We'll get it to you. And then these were just a couple of little extras that I provided just for helpful information that I thought you might benefit from. So I hope that you do find them helpful. Okay.
And we're back.
We're back. I wanted to go back just a little bit. I had a little bit more information that really kind of applied to the repayment process. Once you've settled your case and you've gone into the portal and you've notified Medicare that the case is settled, but actually a little bit prior before that, the reason for putting your case into that pre-settlement status so that you can go back and forth and get those claims disputed off will get you even closer to having a really accurate conditional payment amount that you can be dealing with when you're trying to settle your client's claim. As we all know, well, I'm assuming you know, I'm sorry. When you're dealing with the Medicare program, they do not stop applying claims to your client's conditional payment listing until the day you tell them that the case settled. So frequently, we will resolve a case based on a conditional payment amount, and then we will tell Medicare that the case is settled, we'll give them the attorney's fees, we'll give them the procurement costs, we'll get a lien amount. We will then get issued what's called a repayment demand letter. Medicare issues its demand for repayment. That letter will come with a new conditional payment listing that may include, again, additional claims. And if it does, it's probably going to include claims that don't have anything to do with your client's accident. You've looked at it. You were managing your case all along. You know that conditional payment that you had was completed. Your client, unfortunately, is still a Medicare client. They're still going to medical care. So Medicare has added unrelated claims again, and now they've adjusted. So when your number comes in, if it's different from my formula, it's not my fault. It's the Medicare program's fault. My formula works. So if you get that situation and you're now in repayment demand status, what I would recommend that you do and what you really need to do, pay Medicare whatever it says it's owed. Interest will start to accrue if you don't. So when we're settling a claim for a client, what we do is we always pad the amount that we say is due to Medicare, even though we've run our formula through that worksheet and we generally know exactly what our client's going to end up having to pay. We don't only keep that amount in our trust account. What we'll tell our client is that we're going to hold the full amount of all the conditional payments, not just the full amount of medical bills that was submitted to the Medicare program, not just the conditional payment amount that they paid. That way the money's here, and I explain that situation to them that Medicare is continually looking to increase their claim as much as they can. So they're trying to add claims on, and when the repayment demand comes, it might be different. You can still dispute those claims. You can make a payment to Medicare which stops the interest. If you just dispute the claims and you don't make that payment, and it turns out that some of those claims are related, you're going to end up having to pay those claims back, plus you're going to have to pay interest on them. So when this situation has happened, and it does happen, and it has happened to us frequently actually, where the Medicare program will throw some claims onto a claim, what we'll do is just pay whatever the repayment amount is that the Medicare program is asking for, but when you send in that letter, also title it and send it in as an appeal and state that it is still an appeal, it is a dispute. You can dispute claims even after Medicare is notified that the claim has settled.
You're simply trying to avoid the interest penalty.
Right.
And believe it or not, they don't just take the money and disregard anything that you're trying to do. If you put on the letter appeal and you've paid it off in full, you can still then go through the exact same process we've just described, or really more likely Celeste has just described, in terms of disputing what those individual claims are or those charges are that are unrelated to the accident.
It takes a couple of months, but again, we've had this happen many, many times. You just simply say, I will actually write in the letter to Medicare, we are paying this amount at this time. It is in dispute, but we're paying it to avoid the assessment of interest. And then we actually send them a check. They pay it. We let our client know what's going on. And usually this isn't a significant amount. It's not like you're going to find, $500,000 worth of unrelated claims. It's generally, your numbers end up being a couple $100 or maybe a couple $1,000s off, but you've held the money in your trust account, so you've got it. You're giving it to the Medicare program. They will reimburse your client. They will review those claims. They will take anything that is unrelated off, and they will issue a check right back to your client. Takes a couple of months, but it does work, and it is in there, and it will. It's actually what Medicare recommends that you do. It recommends that you just go ahead and pay it. But even on their website, if you Google it, it will say that that if a waiver or a recovery or an appeal is granted, the debtor will receive a refund. So I just wanted to make sure that was out there. You do have, when you get that repayment letter, it specifies exactly what the process is to appeal if you don't like it. It's basically the same thing as doing a dispute. It's really a very simple process. So I recommend that you do that. All right.
Okay.
Do you have anything else on repayments?
Nope.
All right. So I have Part 7, a couple little extra things that I threw into this presentation just to be able to give you guys. We had a situation that I described earlier in this presentation where we had a young man who was injured in an accident. He was disabled. He subsequently became eligible to receive Medicare benefits, but he didn't even know that he was eligible to receive them. So that prompted me to figure out what exactly was the process with the Social Security disability insurance and Medicare entitlement. So I provided this information here. It's basically So anyone who's over 65 years of age automatically becomes eligible for Medicare Part A. So you understand that, and they receive their benefits. But when someone qualifies for Social Security disability, they also become eligible for Medicare benefits 24 months after they receive, after they qualify for their SSDI. So, and the language that you can find on it is a little bit confusing, but it'll say that there's a 5-month waiting period from the onset of the disabling condition for the disabled individuals to be qualified to receive the SSDI. And so it actually results in a 29-month waiting period. So what I did was just throw you a little bit of information there. So if your client has a disabling accident on June 1st of 2013, and they become approved for SSDI in November, they would actually become entitled to Medicare benefits 29 months later, which would be December 1st. So if you guys follow that math, hopefully it'll make it a little bit easier for you. Additionally, you have a lot of times where a client will come to you, you're handling an auto claim for them, a medical malpractice claim for them. They're 64, they're 63, they're 60. In our case, they're 60. Some of our cases hang around for an awfully long time before they ever settle. If at any point your client becomes eligible for Medicare, your obligation to report the claim begins. You do not want to get in a situation if you have a client and they were injured, 3 years ago. They completed all of their treatment within 1 year. They had private health insurance, everything. But they were 63 years old. And by the time Medicare never paid for any of their care. They turn 65 and you settle their case the next day. That insurance company has a responsibility to report that settlement to Medicare. You're going to get a letter, and the insurance companies only have to report the settlements quarterly. So you could settle your case. It might be right at the beginning of a quarter. It might take 3 months before the insurance company reports the claim to Medicare. Medicare runs it through their process. So you might be talking about, 6 months down the road, you're going to get a letter from Medicare saying that your client, whose claim you settled and all the money you dispersed, owes the Medicare program for all this treatment that they've just automatically thrown on there. I will tell you that causes little mini heart attacks for the attorneys and the staff in my office when those letters come in. If at any time while your claim is pending, if your client turns 65, so set up whatever triggers, calendar reminders you need, encourage your staff to do so. If your client turns 65, you have to get Medicare involved.
Even if there's not going to be any claim?
Yeah.
You just simply want them to open the file and close the file, as crazy as that sounds, so that everybody is on the same page in terms of the fact that there was no claim, even though the person was Medicare eligible.
Right. The easiest way to do that is you simply send them a letter, say, yes, here was a claim, and you use that letter also, notify them that the case is over and settled already, and just provide them with the backup that says all the coverage, there was no treatment during the time that he treated. He finished all of his treatment before he ever became eligible for Medicare. There's nothing ongoing. They basically will open the claim and close the claim, and they'll send you a nice little letter that says, we've identified no claims. This claim is closed. I love those letters.
And then you've done your job by pursuant to the law. So
correct. All right. So that's Social Security. Let's see, what one was this? Oh, the next little slide here is the mandatory reporting thresholds. These get reviewed, I think, every year by the government, by CMS, by the bureaucracy. Medicare, it costs money for the Medicare program to recover money. And so they have established, and again, trying to clear out the overwhelming amount of cases. You've got a little tiny fender bender, a client handles it themselves with their insurance company. Next thing you know, because they're a Medicare beneficiary, there's a claim. But we're talking about a claim they settled for $500 with the insurance company. Medicare doesn't want to be bogged down by that stuff anymore. They're trying to make the process easier. So every year they will review the mandatory thresholds, the mandatory reporting threshold. Last year it had actually gone up to $1,000, that if your claim settles for $1,000 or under, you weren't required to report it to Medicare at all. Medicare has gotten a little bit more efficient in handling its claims, and so for 2017, it's actually dropped it back down to $750. So again, I hope these aren't claims that you're making your living on, but if they're under, if you're settling a client, this actually does happen in our cases where we'll have children that are in the back seat of a car, all perfectly safely strapped into their car seat, or it doesn't really apply, but you're settling cases that are under $500 as children wouldn't have Medicare, but it could similarly happen. Someone's in a car, they're not hurt, the insurance company throws them a little bit of money just to make sure that they go away. If that's under $750, you're not under any obligation to provide it to Medicare, and so this is just information that you can review at your leisure to talk about that threshold requirement for you. All right. My next little slide here is information on the Philadelphia regional office. I wasn't aware that this was could be nationwide or viewed anywhere. I understand that the Medicare program applies to everybody, so but I provided some information on all the contact information for the Philadelphia regional office. Again, this is not where you want to start. You definitely want to work through the process with the Medicare secondary payer recovery contract center, that now BCRC, sorry. But if you actually need to get in touch with the regional office, I threw this information in there for you just for ease. So there's quite a few different pages of that, sorry. All right, and I don't know if any of you are familiar, but a lot of what we've gone over here, there's a lot of information that we've gone over here. Medicare has put together these wonderful, just really cute little flow sheets. I would encourage you to print these out, give them to your assistants. I have one on the wall next to my office. Just it real quickly runs you through what the process is of this particular one here is the overview of the beneficiary NGHP recovery process. If you're not familiar with what NGHP means, another one of those lovely acronyms that the government loves to use, it's called the non-group health plan recovery process. Liability insurers, no-fault insurance carriers, workers' comp insurance carriers are all considered non-group health plans for purposes of Medicare. They're not. They are paying for medical treatment. They're not health insurance companies like Cigna and Aetna that your beneficiary is contracting with. These are liability third-party insurers. So Medicare lumps them all under this NGHP heading, and they've provided this cute little flow chart that just kind of really simplifies the whole process down for you. So I'm not going to.
And it's actually very helpful.
They're great. You can give them to your clients so that they can understand, but you can like make notes on it that says this takes 8 months or this takes 10 months because it's really, really quick and it looks like it's really, really simple. But I'm still, even though the portal has sped things up tremendously, I'm still advising my clients when their case settles that it could take, 6 weeks to 6 months to resolve their Medicare repayment. They love it when I get that repayment letter in 3 weeks, and I do get it sometimes in 3 weeks. It really does come in a lot faster these days. If you're not familiar with the portal, please do go register for it. Get yourself signed up. You'll love it. All right. Our next one is, again, just a little flow chart, and this is actually just the how to go through the final conditional payment process. That activating that new bubble on the bottom screen of the case information page on the portal and putting your case into the recovery status and notifying Medicare that you think you're going to settle your case soon. Maybe not settle your case, but resolve your case because you've got a set trial date or you've got an arbitration or some way that your case is going to get resolved. You definitely want to activate that feature. It puts you in the front of the line and it really gets Medicare. And you'll see even here on this thing, it will say that Medicare has to respond to disputes right there in the center within 11 days of a receipt. So that'll really speed up your process. Once they've reviewed those disputes, though, they're only reviewable one time. So you really do want to make sure that when you're saying this isn't related, that it isn't, and you're providing them with sufficient backup so that they can just go ahead and take it off. All right. Then the very last thing I have to talk about, and this might give Steve some food for thought, and this is really awful. I really don't like this part. Just in the digging around for the information that I wanted to present today, I spent a lot of time on the Medicare website. There are, you can subscribe to email alerts, so they'll send you, updates on when those thresholds change. All of that information is available on cms.gov. Just go check it out, spend a little bit of time on it. So in the process of doing that, for most of us, and I'm assuming that a lot of you that are viewing this are attorneys that handle third-party liability claims. Up until now, Medicare set-asides have not applied to liability claims. They have only applied to workers' compensation claims, and we've been very grateful that they haven't because basically a set-aside is your insurance settlement, your third-party settlement is making arrangements for your client's future care that they're going to need. Up till now, you've been able to settle your client's claim saying that your client might need future medical care and knowing that that was going to be necessary, and so your settlement is based on that, but you haven't had to put that money into a safe account that your client had to use for medical expenses. Your clients have still, up till now, been able to get that money, put it in the bank, use it for whatever they wanted, and still use their Medicare benefits. So in trolling the Medicare website, I came across this release that actually has been sent out by the Department of Health and Human Services to medical providers that Medicaid Medicare set-asides appear to be on CMS's horizon. This is, it's basically stating that for the Government Accountability Office has required that the Centers for Medicare and Medicaid Services will establish 2 new set-aside processes. A liability insurance set-aside arrangement. I'm going to do this. It's the lights. It doesn't work. It doesn't like me. Basically, they've required that they establish 2 new set-aside processes, one being a liability insurance set-aside arrangement, which would be an LMSA, and a no-fault insurance Medicare set-aside arrangements. We have very little no-fault coverage in the state of Maryland, but for those states that have $50,000 no-fault insurance policies, you're not going to just be able to pay the claims. You're going to have to actually reserve money to pay for future treatment that the client's going to need. And this little press release here basically is stating that the effective date of this is going to be October 1st of 2017. I've looked around. I've not found anything further on it. Let
me interject.
Yeah.
This is not the first time that Medicare has announced that there will be liability set-asides or set-asides for no-fault insurance. In fact, historically, they've been saying that they're going to do this for the last, it's got to be 5 to 7 years. They have not implemented it, and the hope is they're not going to implement it now either, but you need to be aware that this is certainly something that could be implemented, and it's still on the horizon. Just because it's taken them much longer to implement it doesn't mean that it's not going to occur. So keep that in mind.
Yeah, I think the previous information that was available was simply a memo that had gone around, I want to say in like 2012, and that was the extent of any information that had come out of the Medicare program in reference to set-asides. And basically it was saying that, you basically just need to counsel your client that they should really be using their money for the information they really should, for their ongoing treatment. They should be using their Medicare benefits, but there was no enforcement behind it. So these are definitely something that is on the horizon that we'll be keeping a very close eye on.
And also previously they'd announced that they were going to implement it, and then said they were going to implement it on a date in 2014, and then as they approached the date and got closer to it, they then pushed it back out again. And so right now it says that it's going to begin on October 1 of this year, 2017. But
it says they have to have the setup is coming. So this is really just a note. If you do read through this, what it's saying is that it's telling healthcare providers that if you have a client who's treating for a diagnosis code that is associated with a liability Medicare set-aside, that their claim is going to be denied because the client Medicare is not going to pay for it. The client has to pay for it. So this is really just advance warning to providers that a change is coming. I've seen nothing. I've received no alerts, no anything from the system, from the Medicare, from the things that I'm subscribing to about it at this point. But something has gone out to providers, notifying them that if the client's diagnosis codes that they're treating them for are related to a set-aside, they're not going to be paid by Medicare. So it's definitely something we want to keep an eye on.
Okay, well, at this point, I'd like to discuss for just a little bit some of the Supreme Court cases that tackle the Medicare issue, and also talk a little bit about proportionality and the ethics of working with or paying Medicare subrogation liens. There are 2 primary cases. The first was a case from 2006, and this is titled the Arkansas Department of Health and Human Services versus Allborn. And then the next case is from 2013, and this is WAS versus EMA XREL Johnson. So let me talk to you a little bit first about the Allborn case. The facts were as follows. A 19-year-old college student, Allborn, suffered severe and permanent injuries as the result of a car accident. Although she possessed a claim against her tortfeasors, her liquid assets were insufficient to pay for her medical care. And so the Arkansas Department of Health and Human Services determined she was eligible for medical assistance, and they paid out $215,645.30 on her behalf through their Medicaid plan. And although this is the Supreme Court reviewing and ruling on a Medicaid plan, this is completely comparable and can be used as well in Medicare issues. So Allborn filed suit against her tortfeasors in Arkansas State Court, in which she claimed damages for medical expenses, permanent physical injury, future medical expenses, past and future pain, suffering, and mental anguish, past loss of earnings and working time, and permanent impairment of the ability to earn in the future. And at one point during this suit, which was again in Arkansas State Court, the Arkansas Department of Health and Human Services, which I'll call ADHS, actually intervened, and they asserted a lien on the proceeds of the matter. And what they argued was that they should be entitled to get repayment of their lien because of all the money they had paid out. Now, the Allborn case at this juncture in state court did not go to verdict. Instead, the parties agreed on a settlement that was done out of court for $550,000. And it should be noted that the ADHS did not participate in the settlement negotiations, and the parties did not categorize the settlement in terms of specific portions representing compensation for specific damages, which is important, which I want to talk about for a second too. Itemization of damages. In Maryland, which is one of the two jurisdictions in which I practice, when you take something to a verdict, the jury is required under state law to itemize all the damages. So the economic damages in terms of medical expenses, past and future, lost wages, past and future, and then pain and suffering, what we call non-economic damages. In Washington, D.C., in Superior Court, there is no such requirement. All the jury is told to do is to award damages. So they just will award one lump sum. And in settlements, and this is true for most settlements that we are engaged in, you're not specifying a specific amount for the medical expenses and a specific amount for the lost wages or a specific amount for the pain and suffering. Well, based on the out-of-court settlement of $550,000, the ADHS asserted a lien against the settlement proceeds in the amount of the entire lien, $215,600 and change. So Allborn then filed suit in U.S. District Court and stated that the lien by the Arkansas Department of Health and Human Services against her settlement violated Medicaid laws because satisfaction of the lien would require depletion of compensation awarded for her injuries other than past medical expenses. And the district court ended up ruling that the ADHS had a right to recover from the settlement proceeds the full amount of the Medicaid payments made for Allborn's benefit, which was the $215,000. That was then appealed to the Eighth Circuit, and the Eighth Circuit then reversed it and said that ADHS was only entitled to recover that portion of the settlement that represented payments for medical care. So from there, the case then went to the Supreme Court. And what the Supreme Court ended up doing is reasoning that it was not, they agreed with the Eighth Circuit and in reversing what the district court said, ruled rather. And what the Supreme Court essentially said is that it's not fair that any settlement should be depleted in that amount when it's not clear how much was really paid for settlement for medical expenses and otherwise. So, and in fact, the Supreme Court came out and said the Arkansas statute, which was the statute requiring repayment, if enforceable against Allborn, authorizes imposition of a lien on her settlement proceeds in the amount of $215,000. Allborn's argument before the district court, the Eighth Circuit, and this court has been that Arkansas law goes too far. We agree. Arkansas statute finds no support in the federal third-party liability provisions and, in fact, squarely conflicts with the anti-lien provision of the federal Medicaid laws. And what this does then, this case specifically, is that there is support because it's not in the statute and it's certainly not in the portal instructions in terms of what requirements Medicare or the U.S. government would have in terms of reducing a lien because of the amount of the lien being more than what the amount of the settlement is. But there is support from the Supreme Court, and even though it looked at a Medicaid statute, the same thing is completely applicable to the Medicare statute. More recently than the Allborn case, which was a 2006 case, is the Was case. And this, again, was from 2013. And in this case, the facts were as follows. A child suffered multiple serious birth injuries, which left her deaf, blind, and unable to walk, crawl, or talk. The child also suffered mental retardation and seizure disorder and required 12 to 18 hours of skilled nursing care per day. The child will never be able to work or live independently. Her parents filed a medical malpractice suit against the physicians who delivered her and the hospital where she was born. And ultimately, the parties came to an out-of-court settlement in the amount of $2.8 million. Like the settlement in Allborn, this settlement did not categorize any of its portions as being specifically related to any of the damages of that the child's parents were seeking. So the court placed 1/3 of the settlement amount in an escrow account until such time as the actual amount of the lien owed to the state could be conclusively determined. And this case, in terms of discussing proportionality, then went on to appeal. And the U.S. District Court agreed that there is an irrefutable statutory presumption, and this was according to state law, that 1/3 of a Medicaid beneficiary's tort recovery is attributable to medical expenses, that was a reasonable method for determining what the state's medical reimbursements should be. The Fourth Circuit, which also is the same circuit that I practice in Maryland. Maryland is a Fourth Circuit state, but the Fourth Circuit vacated and remanded, and they concluded that the North Carolina statutory scheme in question could not be reconciled with the holding in Allborn, that general anti-lien provisions in federal Medicaid law prohibits a state from recovering any portion of a settlement or judgment not attributable to medical expenses. So this case then went from the Fourth Circuit to the Supreme Court of the United States. And the Supreme Court held that in response to Allborn, the state of North Carolina interpreted its statute as defining the portion of the settlement that represents payment for medical care as either the exact amount of the state's past medical expenditures or 1/3 of the plaintiff's total recovery, whichever is less. And the court stated that under this reading of the statute, the presumption operates even if the settlement or a jury verdict allocated a lower percentage of the judgment to medical expenses. And so what the court then ruled is that under the Supremacy Clause, the North Carolina statute was preempted by the federal anti-lien statute. And they explained that the Medicaid anti-lien provision prohibits a state from making a claim to any part of a Medicaid beneficiary's tort recovery that is not designated as payments for medical care. And that's the most important language. If the allocation is not for medical reimbursement, is not for medical expenses that were paid out, then Medicare or Medicaid does not have a statutory entitlement to getting reimbursement. And again, this is in line with their prior decision in Allborn. The Supreme Court went on to say that when the state and the Medicaid beneficiary are unable to agree on an allocation, as Allborn noted, the parties can submit the matter to a court for decision. And nevertheless, an irrebuttable, one-size-fits-all statutory presumption is incompatible with the Medicaid Act's clear mandate that a state may not demand any portion of a beneficiary's tort recovery, except the share that is attributable to medical expenses. And what this essentially is saying is that if you, as a litigant, are in the position of doing what, or being in where what we previously described, where the Medicare recovery is going to so substantially deplete beneficiaries' recovery, especially in light of the fact that it's now seeking reimbursement from expenses that were not solely allocated to medical reimbursement. That is absolutely improper and unlawful. And the solution or the resolution to this problem is for the litigant to then file suit in federal court and have a determination made by that federal court in terms of what really should have been allocated to medical expenses, and therefore what is the right of Medicare or Medicaid to some type of monetary reimbursement. And this is still the law of the land. This is what the Supreme Court has ruled in both cases, and this is certainly the support that I can tell you litigants and as plaintiffs' lawyers that we need in order to ensure that there's not going to be a recovery that's going to make it wholly unworthwhile for our clients to have pursued an action. Okay. And that also fits in with proportionality as well. What the district court would be looking at is, does the proportionality make sense? Is it reasonable? In other words, the district court will be looking at the case from a perspective of, because the settlement or verdict was awarded in a lump sum without any specific allocations to any specific itemization of damages, that what they're looking for is reasonableness. What they're looking to do is to see that the division and ultimately the amount which is going to be made payable back to Medicare or Medicaid, that amount is reasonable and that essentially everyone would be satisfied, other than Medicare or Medicaid, which will probably be getting less than what they had originally hoped to get. The last thing I want to just take a few minutes to talk about is ethical issues in Medicare subrogation. And what we had talked about earlier in this program is the fact that the Medicare lien is what we call a super lien, and that everybody down the line, from the issuance of the settlement check from the insurance company to the defense lawyers to the plaintiff to the plaintiff's lawyers, we're all on the hook if Medicare doesn't get repaid. And by on the hook, I mean Medicare can pick and choose whomever they want to go after to get their money back. And that's why everybody is ultra careful about what's going to happen to the money that needs to be repaid to Medicare. So a few things that I would tell you. Number one is, you don't want to be in the dark about whether your client is a Medicare recipient. And I know that Celeste has gone through this, but I can't emphasize this enough. She has very successfully instructed and trained the paralegals who work under her to do exactly what she does, which is, number one, get the age and date of birth of the client, and number two, find out right away whether that client is a Medicare recipient. Because if that client is Medicare eligible, then you are required to contact Medicare and have them open up a claim. It's a pain. And it doesn't matter, as we described before, whether they have even had any claims paid by Medicare. But you have an ethical duty to do that. And I'll go one step further. If you don't do that, and I don't know, I have not researched this, but I do believe that this would also be what we would call a grievable offense. In other words, if you've left your client high and dry by not describing and informing your client that there are obligations under the Medicare statute for repayment, and you let them go on their way, and then, as Celeste described, 6 months down the road, lo and behold, to their unbelievable shock and chagrin, they receive a letter from Medicare stating that they now owe $25,000. They're not going to be happy. You're not going to be happy. And I think that the grievance committee overlooking you is not going to be happy either, because you have a duty as the lawyer to make certain that the client is completely informed about everything, and that includes the Medicare lien. And so
We've
that's
actually had clients come to us from other law firms when they were getting ready to settle their claim to ask our opinion because they were being told by their other attorney that they didn't need to worry about the Medicare claim. And they were like, "Is that right?" And I'm like, "No." We've actually gotten involved in cases immediately at the end of a case because the attorney that the client had wasn't interested in dealing with the Medicare claim, didn't want to resolve the Medicare claim, and when just said, "Oh, don't worry about it. They haven't notified you. They haven't told you about it." A Medicare claim is nothing like a health insurance claim. A health insurance, they have an obligation to tell their client that they are asserting a lien. They have an obligation to review the claims that get submitted to them to see if they appear as if they were the result of an accident or an injury, which might result in a third-party liability claim. And if so, they reach out to their clients. They've also written it in their policy language. But the insurance companies have a responsibility to take some proactive steps to go and get recovery if their insured makes a third-party claim. The Medicare program does not have that responsibility. It is your responsibility to tell Medicare that it has a claim. It is not Medicare's responsibility to tell you it has a claim. So definitely, and double damages, right?
Yes, there are penalties that can apply. Plus, I'm talking to you from the perspective of a plaintiff's attorney. The defense attorneys are also on the hook.
Absolutely.
So
the insurance company.
Absolutely. So one of the other things, and defense lawyers do this, and I may argue against it, but when push comes to shove, this is the right way for a defense lawyer to handle it, is to put a Medicare indemnification clause in a release. And what that does is, number one, it addresses the Medicare issue, stating that, either they know or they don't know that the person was Medicare eligible or was paid Medicare benefits, that it's the plaintiff's responsibility to, through his counsel or her counsel, to make the payment to Medicare, and then they'll go one step further and say, if you mess up, you're indemnifying us, because if you haven't done what you are required to do under the law, and the United States government comes after us for anything that we have to pay, and oftentimes the indemnification clause will include attorney's fees and expenses, you're now on the hook for that. And again, what you don't want to do is be left in the position of not really being able to represent your client fully, not being able to negotiate what the Medicare lien is. We talked before about the fact that the waiver request is really the Hail Mary pass. When everything else has gone south.
Use compromise.
Exactly, and you have nothing else to work with. You find yourself doing what we as plaintiffs lawyers unfortunately often do, but we're on our knees begging for some type of either more money or a reprieve. And so that's exactly what you find yourself doing. And so it's important ethically that you stay out of trouble by finding out exactly what your client has or is eligible for in terms of Medicare benefits, and then making sure that you've reported it or opened a claim. And again, I can't stress that enough. There are lots of cases out there that have been adjudicated by attorney grievance commissions or committees that, or any body that any committee that governs lawyers in a jurisdiction, because a lawyer has failed to satisfy an obligation to pay a lien and has left the client in a precarious situation. And I can tell you that it is even worse if it's a Medicare lien, because everybody, knowing that they're on the hook, goes out of their way.
Because Uncle Sam's going to get you.
Exactly right, to know that there's a lien and that anybody can be liable for paying it, and that they don't, and that the only way to stay out of trouble is to have addressed it early.
All right.
I think we're done. If you have any questions, please.
You have to check to see if any questions come in. We're okay. So
Okay, yep, okay.
Keith
So,
has some closing remarks.
My Law CLE and the Federal Bar Association would like to thank you for your participation in today's broadcast. As stated during the beginning of today's class, the link to the online evaluation form is now displayed on your screen. After you fill out the evaluation form and submit it, a credit form will be emailed to you within 3 to 4 business days. You may now disconnect. On behalf of Celeste and myself, thank you very, very much.